'cause you can, you won't, and you don't stop. Or when you can, you won't, and you don't stop.
Let's get down to the nitty-gritty. We know that the firm actually is a legal fiction. Okay? Yes, it's a legal entity, but really a firm can't do anything. It's only people who can do things. We also know that one of the markers of the firm, one of the key attributes that has driven its adoption and arguably benefited society hugely, is the limitation of liability for the shareholders, who some people might call owners. Whether or not they are, we can have another discussion. But so if we have the owners/shareholders are not accountable for what the firm does because of this limited liability, the question becomes, well, does that mean that firms can do whatever they want? That no one's really accountable for the decisions that occur within the firm? And the answer would be no. There is a legal framework that makes certain actors liable for the decisions that occur within the firm. And that's what we're going to have a look at in these last couple of weeks. So let's have a look at the basis for accountability and where it starts with virtually all firms. To understand each individual company, we have to understand the rules that the company runs by. And Section 134 of the Corporations Act says that the company's internal management can be governed by the Corporations Act. Okay, so it's governed by the Corporations Act, as we would expect. So it's governed by the provisions of the Corporations Act that are the replaceable rules. So there's a series of rules embedded in the Corporations Act that decide how a company will be run. So a company can be run by that, by a constitution. So it can be the internal management. The rules of internal management can either be the replaceable rules, the constitution, or a combination of both. Okay? So there's a set of rules in each company that decides who has power and who can actually make decisions. This constitution and replaceable rules are a contract. They're in fact a statutory contract between the company and the member, between the company and the director, and between the members and the other members. Okay? So it's a contract between, we have the directors, so we've got the board, and we've got all the directors on the board, and then we've got all the shareholders out here. Okay? So if you think about it, the board and the directors are the internal management of the company, and the shareholders or members are the external group who've supplied the capital. And so the Constitution acts as a contract, right? It acts as a contract between the company and the member, between the company and each director, okay, between the company and each director, and it acts as a contract between the members. Okay. Whew, hard to understand. Well, not really hard to understand if we go back to our idea of agency, right? Because you remember we have a principal and an agent. So in the form, in this company form, the principal is the company and the agent is the director. Okay? So in a sense, this is this. Okay? It's a special case of this. And then we also have the contract between the company and the member, because it's a separate legal entity, and between the members, right? So that's why there is no mention here of between the members and the directors, right? There is no contract between those two. because the contract is between the members and the company. The directors are the agents of the company legally. So that's the legal basis of the Constitution. It's this statutory contract between the company, the members, and the directors, and it isolates who has the power between those. Now, you can divide this power up a little bit differently, but traditionally and in nearly all cases, this is the standard way that power is divided. It's contained in the replaceable rule. Sometimes it can be replaced by what's in the company's constitution, which is often the exact same wording as this replaceable rule. What it does is it gives directors all the power to make the management decisions for the company. The members don't have any. Right? The members' main power is to remove the directors. They can have some other powers, for instance, to change the constitution, etc. That's a bit beyond the scope of our course this time round. So the important thing to remember is the management of the company, right, is given under the replaceable rules, under the constitution, to the board of directors. And the members generally have no power to direct the company. Instead, that's the role of the directors. As Replaceable Rules Section 198A states, very simply, the business of a company is to be managed by or under the direction of the directors. Really importantly, directors. So that means it's the board or the group that actually directs, not any individual director. Now, if we put together these ideas graphically in terms of how a company is regulated, it becomes clear how complex the situation really is. At the centre of it is, yes, we have the company, the corporation, but the main rules working out who has the power to do what are contained in that company's constitution, often a written document and/or a combination with the replaceable rules which are contained in the Corporations Act. That organisation, that entity, then has to comply with the government's legal framework, the laws. So we have that hard regulation over which it has really no control, right? It has to comply with laws, occupational health and safety laws, the Corporations Act, so many laws, depending upon what kind of organisation or company that it actually is. Then the second thing that it has to do, really comply with the expectations of its key stakeholders, right? It's going to be regulated by the market, by suppliers, by expectations in the community. And depending upon how reliant it is on those stakeholders, it may be more or less regulated by those groups. Now, I really want to make a point here. When we're talking about corporate social responsibility and stakeholder regulation, we're of course talking about expectations beyond the law, right? So if you have a minimal level of regulation that's required under law, say anti-discrimination legislation, right? That's not CSR. Complying with that is not corporate social responsibility. That's compliance. You have to. You have no option, right? Regulation may be you try and achieve certain targets for certain groups. That's going beyond what's required by the law, okay? So that's the difference between this stakeholder regulation and legal regulation. And I think it's really important to understand that. One, you have an option to do, one, you don't. And when I say you have an option, I mean it's not legally required. You may not really have an option if a stakeholder group has a huge impact on your business. And then finally, we have this series of self-regulations that companies take on. For instance, codes of conduct, values, etc. So as you can see, it's quite a complex set of expectations through regulation that are required of an organisation, and there's these multiple accountability mechanisms at work, which makes the whole system, as you can imagine, quite difficult to manage and quite complex. Okay, so that's an introduction into regulation and accountability. But is regulation actually a good thing? Well, that's the subject of debate, and in the next video, we're going to be looking at some insights into that from theory, through some theories of regulation.